The difference between separate property and community property in a divorce always seems to carry a lot of confusion with it. So one of the most confusing areas is what is the difference? And many people think that community property means 50-50 split. So today we have with us Greg Beane, and Greg is a family law attorney with the Webb Family Law firm in Dallas, and he's going to shed some light on these mysterious questions. So, Greg, welcome to our show today. We're so glad to have you, and tell us a little bit about yourself.
Oh, thanks, Elizabeth. Glad to be here. Glad to see you and Allison both. A little bit about myself. I'm a partner at the Webb Family Law Firm here in downtown Dallas. We have offices in Dallas and Fort Worth. Our firm has 6 attorneys, and we specialize in family law. As a matter of fact, all 6 of our attorneys are board certified by the Texas Board of Legal Specialization in Family Law. I've been doing this, I was licensed in 2006, so this is my 17th year now in family law.
Wow. So is it, I often wonder, is it like a hard business because you're dealing with people's emotions and their money and their life and all that? Do you go home at night and just sometimes wonder why you're doing it, or you just absolutely love it?
All of the above. Of course, family law is a little different because we are dealing with a lot more emotions than a lot of other areas of law deal with. But that's also part of what drove me to want to do family law. That and family law kind of encompasses other areas of law as well. So you can't just learn family law. You have to know something about civil and some about real estate, some about criminal law, unfortunately. I guess, again, the answer to all of those questions is yes.
That makes sense. So today we're talking about separate property and community property. And in my conversations with clients, it seems like the lines are really blurred in their mind and they don't really understand. So can you share with the audience what is, I guess, the overarching difference between the two?
Sure. Most people, like you said, have heard the term community property, but most people don't know exactly what that means. So in the state of Texas, we're what's called a community property state. And a court in a divorce can only divide community property. They can't touch separate property. So what does that mean? All right, let's start. Actually, I think it's more helpful to start with the definition of separate property, and then we'll go into community. So separate property is property acquired before marriage or property acquired during marriage by gift, inheritance, or the result of a personal injury settlement. And there's some exceptions to that, but we'll stay away from that right now. So community property is property acquired during a marriage unless it's a gift, inheritance, or the result of a personal injury settlement. So in every divorce case, there will be 3 estates that we deal with. That's the community property estate, there's spouse one's or husband's separate property estate, and then wife's separate property estate. So you have 3, but the court, by the Texas Constitution, can only divide community property. They can't divest someone of their separate property. When a divorce occurs, it's presumed that all the property the spouses have is community property. So we start with that presumption. And if one spouse says, well, I have separate property, then they have to prove to the court by what's called clear and convincing evidence that it's separate property.
The exceptions to community property would be things like inheritance, gifts, and things of that nature. So if you had a prenuptial agreement, that would also define beyond a shadow of a doubt, or does that really hold the water that people think it does? Like, hey, I'm getting married today, we have a prenup, and this is mine.
Right. So yes, that is a typical prenup provision or a premarital agreement provision that we have in the state of Texas. Those are pretty ironclad. They're very difficult to set aside if they're drafted properly. And typically, you'll say in a premarital agreement, whatever you had going into the marriage is separate property and will remain separate property. So one thing that I didn't discuss earlier in the definitions of separate and community property is any income from separate property is community property. So let's take the example of a retirement account. You have $100,000 in a retirement account on the date of marriage, but that increases to $110,000 a year or two in, and those are based on dividends, interest, something like that, right? The income from that $10,000 would actually be community property, and the $100,000 would be separate. So that's what we would do in a premarital agreement, is say that $100,000, that retirement account, is separate property, and any income resulting from that would also be separate. So if a divorce occurs, that would certainly make it a lot easier to figure out what's separate and what's community. A lot of times in premarital agreements, we'll even say there will not be a community estate. There will only be the separate property estates of both spouses. So there's nothing to divide.
That's really interesting. So then back to your example of the 401k. So the dividends and the interest income become community property, but what about like starting the day after we're married, I'm still making payroll contributions or contributions through payroll to my account. Are those also considered community property?
Yes. Whatever income you earn during the marriage is community property. And if you're putting that community property into that separate property asset, you're going to have a commingled asset. You're going to have some that's separate, some that's community. And we see this all the time. And in short-term marriages, it's easier to prove separate property. But if you have somebody that's been married 20 years, and at the end of 20 years, they're getting a divorce, and they say, well, I had $100,000 in my IRA or 401k, whatever it is, on the date of marriage. Well, that's going to be really hard to trace, because we're going to have to go through every transaction over the past 20 years to find out what's separate and community. So another wrinkle in this, the actual separate property assets in those 401ks or IRAs are the shares of stock that are owned. So if that stock appreciates in value, you have a share of Apple in your 401k. And on the date of marriage, it's worth $100. Today, it's worth $600. The separate property is the $600 because the property is actually the share of Apple. Does that make sense? But if it kicks off dividends, then those dividends would be community. And if the dividends go and buy new stock, which happens all the time, then that becomes community. So, and typically financial institutions, it's hard to get statements from over 7 years prior. So if you're trying to go back 20 years, it's very, very difficult.
That does sound a little bit like a nightmare. I do some day trading, and I know just that reconciliation for tax purposes is crazy.
Right.
So I can only imagine. I mean, even if you were only going back a couple of years, and you have an active account that's purchasing, and you're rebalancing, and you're moving stuff around on a regular basis, that could obviously would require the need of a forensic accountant, I would imagine.
Absolutely. And we use forensic accountants all the time to trace out separate property like that. Yeah.
So Greg, something that comes up a lot with my clients, and this is a current conversation I'm having with a client. She purchased her house before she met her husband, lived in it for 2 years, put a $20,000 deposit down on it. Now, 20 years later, they're getting divorced. The first 2 years she made payments on it, she understands that the decrease in the principal balance on that was pretty negligible. How would the court view that $20,000 down payment she put on the house? Would that still be her separate property, or would that go into the division of property during the divorce?
So in this example, I'm assuming the deed is in your client's name. She bought it 2 years prior to the marriage, right? Then the house is her separate property. So the entire house is her separate property. Now, what you would have, the community estate would have a reimbursement claim against her separate property. And it's for the amount of the reduction in principal of the mortgage, because presumptively what's happening during the marriage is both spouses are earning income, or any spouse is earning income, and that income is going to pay the mortgage. And so the community estate's paying down on her separate property and increasing the value of her separate property by lowering the debt. So you would have, and this happens quite frequently, the example you're giving is, one that happens all the time, but where one estate has a reimbursement claim against the other. So other examples of reimbursement claims like that are if the community estate paid for renovation of the kitchen or the bathroom or whatever that increases the value of the house. That's also another reimbursement claim. So that's how the court would view that. It goes back to what I said about the Texas Constitution. You can't divest someone of their separate property. A house can't be commingled, okay? If it's separate property, it stays separate property, but it may owe the community money.
I've had one of those, or actually a couple of those before, and one of them was even a little bit stickier because the husband owned the house pre-marriage. They get married, and then the husband becomes pretty much a deadbeat and doesn't work. So the wife is working and maintaining the house for like 10 years. And she came to me and they had refinanced. And of course, in the refinance, she had to put the mortgage in her name because he didn't qualify. So now she thought she had ownership. And I had to explain to her, you have an interest in the house, but you don't have ownership. It's his house.
Correct.
And so this much of, you got to go do the paperwork, but to figure out where you start and where you are and how much you put in, but it's still his house.
Right. A deed of trust is not ownership. It's not a deed. Exactly. As long as the deed stayed in his name, then it's still his separate property.
Now, I have an interesting one that has come up just this past week of a gentleman, and he's elderly, and his wife left for work and decided not to ever come back. And she's wanting the house. And his situation is that he married her like 4 or 5 years ago. And when they married, he owned one house and he owned it free and clear. And during the marriage, he retired and sold his business, and he sold that house. And with that cash, they went and bought a new house. And so he was asking me, am I like in jeopardy here of losing the house? And I told him, I said, well, I'm not an attorney and I can't give you legal advice, but based on what I know and what I understand, she may have some degree of interest in the property, but it sounds like that was your sole property or sole cash, your sole stuff, whatever you call it, that went in to purchase the house. Is that somewhat correct?
Possibly. It depends on a couple of things. Number one, I'm assuming he had the business before the marriage as well.
Yes.
Assuming it's some sort of entity, a corporation, an LLC, something like that, then that's probably going to be his separate property as well. So sells the house, sells the business. That sounds like both separate property. And that money goes directly into the new house. So we can trace, assuming, all these transactions that go into this house. Now, the question is, and what you see a lot is a situation like this, but he's married now and both of their names appear on the deed. So that makes it more complicated. We can certainly say he has a separate property interest in the house, but maybe not 100%, because what wife's going to say is he gifted me that half interest because I'm on the deed. And that does create the presumption of a gift, making it half and half separate property. Like I said, you see that quite often, and that's what most spouses say when when they're on the deed, but the other side paid the entire thing out of separate property. Well, he or she gifted that to me.
Talking specifically Texas law, but so many states now have community property, separate property. Do the Texas laws run fairly similar to the majority of states, or is it truly a case-by-case state decision on what's separate and what's joint?
It's state by state, and you know, I'm only licensed in the state of Texas. I've talked to attorneys in other states as to kind of how they do it, and you know, the majority, I think, are actual community property states. But each case does it just a little bit differently. Actually, in the Texas Family Code, you know, we define separate property, we define community property, but the majority of the law is based on case law. It's based on case by case things that happen in a certain court, and those get appealed, and then, you know, we have to follow the case law. So most of it's done that way, and a court in Texas may decide something differently than a court in California or Florida or wherever. So a lot of it's slightly different.
Okay. And that's good for people that are listening from outside of Texas. I don't want them to confuse what we do in Texas. They still need to refer to the laws in whatever state they happen to be living in.
Yeah, absolutely. For example, Texas does not recognize legal separation, whereas California, to my understanding, does. And whenever the parties separate, community property stops accruing in California, but not Texas, because there's no separation. So you may file for divorce. The case may take 3 years to get to final trial, but community property is accruing the entire time. So, you know, I know that's something different than California does.
That we all know that in Texas, we just like to do things differently than anywhere else.
Sure.
So, Greg, one question that comes up a lot is, my husband left, we filed for divorce. He filed, I filed, everybody filed. We all got it all on there. Then we went to mediation. Now we're getting to the hearing. What is the actual date that assets are divided in Texas? What is that date that people need to keep in mind?
Typically, it's the date of divorce, or the date of trial. In the case that you just mentioned, if there's a mediated settlement agreement, then you can agree to divide the assets upon the signing of the mediated settlement agreement. I personally am a fan of putting that in mediated settlement agreements. Just say, as of today, we're dividing everything. I know some people aren't, and some people will have it accrue through the date of divorce. So if you go to trial, it's typically through then.
So we've been talking about assets. What about debts? How does that play out in community properties? And not just like the big pieces, the mortgage or the cars, but even down to the credit cards and all the other ancillary things.
That's a good question. And the general rule is whoever incurred the debt's probably going to get it. If husband has credit cards in his name, he's going to be awarded that credit card debt. Why is that? Because the credit card company is looking to him for payment. And that's why his name's on the card. So you don't really want wife to be in charge of paying husband's debts, because if she doesn't pay it, what happens? Husband's credit's ruined, hers isn't. So typically the person that incurred the debt's going to get it. If it's a joint account, then the court will divide it up one way or another, or maybe there's an asset that's sold to pay off the debt, something like that.
Yeah, I see a lot where people have the joint cards, and they assume, because it's been awarded to the other party, that they're not contractually responsible anymore. And then that other party quits paying, and they don't understand why that's showing up on their credit report and why they're responsible too, and that sort of thing. And I've tried to explain that just because a judge awarded the debt to the other person, he can't modify a credit agreement between you and a creditor. And so unless that card is closed and a new one open, you are still responsible in the creditor's eyes.
Absolutely. Yeah, because the creditor's not a party to the divorce.
Right.
Nobody's suing Chase or MasterCard or whoever. They don't have a representative at the trial. So, the court has to go with whatever agreements they had. I mean, this applies to real property too. And that happens all the time if, typically the mortgage is in both parties' names, but they get divorced and let's say wife gets the house, and if she doesn't pay the mortgage, that's still on the husband. Because typically courts don't order a refinance because they can't order a mortgage company to lend them the money for the same reason. So you can do, deeds of trust to secure assumption where the other party's awarded an interest in the house and can, step in and pay off parts of the mortgage if there's a default, and then can foreclose on it. So that situation can occur. But typically people think, well, they should have to refinance. Not necessarily.
Well, and a lot of times they can't.
Yeah.
They can't qualify.
Exactly.
Whether they don't have the income or they don't have the credit score or, lots of reasons that they may not qualify. And, I also have had experiences where a client finds out, and that's always way too late, but they find out that the house that was awarded to the other party that they're joint on the mortgage with, and that person did in fact quit paying and went belly up. They find out like way too late that the house is in foreclosure or something like that, because they're no longer at the residence to receive the mail to find out anything is going on.
Right.
And it's a tough spot to be in.
Yeah, it is, for sure. So, a lot of times we'll write in divorce decrees or something like that the spouse that is still on the mortgage has a right to see the mortgage statement and, make sure that everything's paid, something like that. And if there's a refinance, then a lot of times when a court may refinance is say that if this spouse wants the house, then they have to refinance it within 90 days or something like that. And if they can't qualify, then it's going to be sold.
One right now, and we've got, I think, 3 weeks left to get the refinance finished before she hits her drop dead date. And in the meantime, the husband is chomping at the bit and harassing her, to get it done. And she's trying to do it quietly because she doesn't want him up in her business. But it's always interesting to be in the middle of those.
I can't imagine that from your side. So that's one of those things where if the parties agree, then and don't have to go to court, then there's a lot more flexibility on what you can do. When you go to court, the court is much more limited on what they can order than what the parties can agree to. They can agree to refinance within those days, and they can agree to any number of different ways to make sure that they're both protected in something like the sale of real property, where the court is basically going to award it to one party or the other or sell it, period. And not worry as much about the credit score. Can the person qualify and those things. So that's a lesson to those that want to fight and go to court. Just remember that.
So much great information that Greg has unpacked for us today. And hopefully now you have a clear idea, or at least a clearer idea, of the difference between separate property and community property. And as Greg mentioned, if you're starting to get your paperwork together and get ready to meet with an attorney, feeling overwhelmed, not totally sure what all you need to gather, be sure to check out our video. It's titled Getting Your Paperwork Together for Divorce. So check it out. In that video, in the description below, there is a link to download a checklist. So go check it out. And also, if you found value today, please give us a like, comment below. Be sure to subscribe, ring the bell. And of course, if there's someone else that you know that could benefit from this information, please share it with them.